Okay, we are live on YouTube. This is the bond matter of State of Georgia versus Ariana Wilson Presley. So they're at the jail. If you're Miss Wilson Presley, just wave at me to confirm that. Thank you, ma'am. And representing the state is Miss Thomas, and representing Miss Wilson Presley is Mr. Lewis. And Mr. Lewis, I'll turn it over to you.
Thank you, Judge. Judge, before you is Miss Wilson Presley, as you have already informed all anyone looking. Miss Wilson Presley, Judge, you found cause on to bind her matter over to Superior Court on 5 counts of aggravated assault and 1 count of criminal damage in the second. Um, During the live testimony, and this being germane directly to the issue of bail in this particular case, the officer was the only witness, the detective was the only witness to testify. And at that time, the detective told us that he believes Ms. Wilson Presley to have fired 5 shots from a Glock 23, with one of the shots striking the ground 3 feet away from her, and 4 of the shots impacting areas on an automobile that was on the roadway adjacent to where Miss Wilson Presley worked. Miss Wilson Presley was an employee at the Dollar General, where 2 people came into the Dollar General, began berating, threatening, and accosting, were herded out of the store by the manager. And though the berating and insulting and threatening was directed towards Miss Wilson Presley, that when Miss Wilson Presley came to the door of that store, a cup of what all now believe to be water was thrown on Miss Wilson Presley. And in response to that, Miss Wilson Presley uh, discharged a firearm that she had that I've already talked about. One of the persons having thrown the liquid, which we now believe to be water, was arrested, and Miss Wilson Presley was arrested. Um, Judge, the testifying witness says that he believes that Miss Wilson Presley had no prior knowledge of these people, and did not believe that there was any other relationship other than the fact that they came to the store, and in the course of doing what I've already talked about, did some damage inside of the store as well. Judge, Miss Wilson Presley turned 18 years old in July of this year. Um, she resides in Riverdale, Georgia, with her mother and her 2 younger siblings. She has an older male sibling, but he no longer resides in the house. He is older than she is. Her mother's name is Jermilla Presley, and I will bring Jermilla Presley in with us in a minute to testify on issues related to bail. Mom, daughter, and the 2 minors, well, mom and daughter have resided there since in this address in Riverdale since 2019. I don't know how long the younger siblings resided there because I don't know how old they are. So, and that's my failure there to get that information. Um, my client is a 12th grader presently at at Perry Career Academy. I apologize. At Perry Career Academy, where she is expected to graduate this year, or in the 2025, Judge. My client has never been arrested before in her life. She has never had any issues of failure to appear in her life. Um, and as has already been stated, the purported victims in this case came to where she was, uh, and began the activities which garnered the response that they did. Judge, she has worked at Food Depot, the place where this event occurred, for 3 months. Before working at Food Depot, she worked for 2 months at Sonic's, and somebody's talking over the top of me. I don't know who that is, Judge, but I'd ask them to extend the courtesy. Before working at McDonald's, at Sonic's, she worked at McDonald's for 5 months. Um, she has no children of her own. Um, she herself was born in Alabama, in Birmingham, but she has been a resident in the state of Georgia since kindergarten, so roughly about 14 years. Um, so, Judge, that being said, I want to now share a screen with you and ask the court to admit Ms. Jamila Presley to the conference. I've just sent her the link to join.
Okay.
While we're waiting on her to join, Judge, I am looking and have shared with the court OCGA 17-6-1. Judge, in particular, I'm looking at paragraph E and subparagraph 1. I'm under A, I'm looking at paragraph A. And paragraph A, of course, asks the question, is my client a threat or of leaving the jurisdiction or fleeing the jurisdiction? I would submit to the court that she is not. She's a high school student. And when this event happened, she was at work in the community. When this event happened, she was still living in her mother's home. And she has resided in the state for the last 14 years. Paragraph B poses no significant risk of danger to any victim, witness, or to the community. I would submit to you that her criminal record suggests that she does not pose any threat or danger to the community. She has never posed a threat or danger to the community. I would submit to you that she poses no threat or danger to any victim or witness. In fact, in this particular case, she was not the primary aggressor. Paragraph C asks about whether she poses a risk of committing any additional felonies if released on bond. I'll submit to you that she hasn't committed any felonies at all. Right now, even with the events that she has been accused of, the court is required by Ayala, we're talking about Ayala versus State, to still presume that she is innocent. So right now, she hasn't committed any felonies, nothing in her record, nothing alleged by the testifying witness, and nothing whatsoever other than an allegation that she did the things that were testified to on Wednesday. D talks about intimidation of witnesses or obstruction of evidence. I would submit to you that she poses no risk to do that because she's never done it before. And in this particular case, the witnesses talked about what they believed occurred, which is somebody coming and threatening her on her job. As far as the administration of justice, we didn't receive any testimony about that during the preliminary hearing, Judge, but I doubt at this age if she would even know how to obstruct the administration of justice. Judge, subparagraph 2 under E talks about the things that the court should consider when giving bail. I'm going to hold on that and ask, has my witness been admitted to the conference?
Okay. I have not yet, but I see her in the waiting room. I'm going to admit her now. Okay. And so can you unshare your
Unshare for a
screen?
moment, please.
Yeah, and
I'm turning to my facilities manager here just to do just that.
gotcha.
Uh,
All right.
wait,
And so
wait.
Miss Presley, Jermella Presley, if you can turn your camera on. All right, thank you, ma'am. All
All
right, Miss
right.
Press. Yes, Mr. Lewis, you can swear her in.
Thank you, sir. All right, ma'am. Would you please raise your right hand for me? Do you swear or affirm that the testimony you're about to give this court will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Wonderful. Would you please lower your hand and spell your first and last name for me, please?
Jermella
Hmm.
Presley.
Wonderful. Miss Presley, what city do you live in?
Riverdale, Georgia.
Wonderful. And do you live in a house or an apartment?
A house.
How many occupants are there living in your house right now?
Well, currently, me and two small children.
Hmm. And you qualified your statement by saying currently, is there another person that lives in your house?
Ariana does.
All right. And that would be Ariana Wilson Presley, is that correct?
That's correct.
Okay. Now, if Miss Ariana Wilson Presley were not confined in the jail, would she be living in your house if released?
Yes, sir.
Hmm. And you said that there were two minor children also in your house. Is that correct?
Correct.
How old are those minor children?
7 and 3.
7 and 3. And how long have you lived in Riverdale, Georgia, at your present location?
Since February 2019.
Hmm. And how long have you lived in the state of Georgia?
Since about 2012 or 13.
Hmm. And your relationship to Miss Ariana Wilson Presley, again, what is that?
She is my daughter.
Hmm. Do you have any other siblings or relatives living in the state of Georgia?
I do.
Tell me about them, please. Where do they live?
I have two sisters. They live in DeKalb County.
All right. And then do you have any other children as well?
I do.
And how many other children do you have?
I have a son.
And what state does he reside in?
Atlanta, Georgia.
Atlanta, Georgia. All right. Now, this house that you live in, is this house in your name?
No, sir.
All right. Do you participate in the ownership of the house, or are you just a person living there at the generosity of someone else?
I'm just a person living here.
All right. And are you employed, ma'am?
I am not.
Why are you not employed?
I am a caretaker for a disabled child.
All right. Is that disabled child one of those minor children that you talked about, the 7 or 3-year-old?
Yes, sir.
All right. And so we've heard that Miss Ariana Wilson Presley resides in your house. Does she contribute to your household's income?
She does.
What does she do with respect to income for the house?
She helps pay a bill.
All right, understood. I'm going to give you a series of names now, ma'am, and I would like to know if you know these individuals, okay?
Okay.
Do you know a Jada Powell?
No, sir.
Do you know a Jania Jones?
No, sir.
Do you know Brazil Harris?
No, sir.
Do you know, I'm sorry, do I need to pause for a minute?
No.
Okay. Do you know Michaela Bell?
No, sir.
Do you know Alonzo Brunson?
No, sir.
All right, wonderful. Now, we've heard that your daughter was in a possession of a gun. Have you ever seen your daughter with a gun before?
No, sir.
All right, so do you know how she might have acquired a gun?
I do not.
All right. Okay. If your daughter were released from custody, does she tend to mind you when she's living in the house? In other words, obey your rules?
She does.
Do you feel like you would be helpful in encouraging her to make or meet any court dates or responsibilities that she has?
I will.
All right. And do you believe that you'll be able to curtail her activity and ensure that she doesn't receive any weapons or anything like that while she's out on bail?
I will.
Uh-huh. And do you believe that you'll be able to prevent her from it by exercising your parental authority from threatening or intimidating any witnesses?
I do.
All right. Thank you, ma'am. That's all the questions I have for this witness right now, Judge.
Okay, thank you. Ms. Thomas, do you have any questions?
Yeah, Sean, very briefly. Ma'am, you're originally from Alabama, correct?
Correct.
You have any relatives still living there?
Objection, relevant.
I'm gonna overrule.
Thank you, ma'am.
Mm-hmm.
Do you have any relatives still living in Alabama?
I do.
Who would they be?
Objection, relevant.
Yeah, it's very relevant when we're looking at the different criteria for bond, one of which would be risk of flight.
Yeah, and I think there was evidence submitted or brought out here as to where the immediate family all resided. I think it's sort of in line with that same kind of questioning, so I'm going to overrule the objection.
Thank you, ma'am. Ma'am, who still lives in Alabama?
One of my kids' father.
You have any other relatives, mother, great aunts, any other relatives there?
No, ma'am.
What about your daughter's father? Is he still there?
He's in jail, yes.
But he's still there?
Yes.
Okay. Now, ma'am, were you present when all this happened?
I was not.
And do you have any idea where your daughter got the weapon?
Ask and answer, Judge.
Yeah, that is relevant. I'm following up on defense counsel's question when he asked her about weapons.
The objection wasn't relevant, Judge. It was asked and answered.
I didn't ask her about a weapon until now.
I did.
But I can follow up on that.
Yeah,
Mr.
I'm going to overrule.
Thank you.
Mm-hmm.
Ma'am, do you have any idea where the weapon came from?
I do not.
So it's something that she concealed from you, that she had a weapon?
Objection, Judge. Calls for speculation.
She can answer yes or no, Your Honor. That's not a speculative item.
It assumes that she possessed a weapon, Judge. And right now, she's presumed innocent.
Yeah, we're not talking about whether or not she's guilty or innocent. We're talking about whether or not she had a weapon. As the court may recall, there was testimony in the preliminary hearing on Wednesday that at least 7 people saw her with a weapon.
And there was testimony by the defendant.
Videos that captured her with the weapon.
There was testimony by this young lady who's testifying that she doesn't know of her daughter having a weapon.
But that's not my question.
Your question was, did she conceal having a weapon?
Yes.
And I think in terms of what the witness would know, the witness would either be aware of it or not. I think you're asking her mother to assume that these reports of a weapon are true. If you're asking whether it was concealed from her, I think in terms of knowledge that she would have, it would be whether she's ever seen one, knew of one at all. So I'll sustain the objection.
Yes, Your Honor. I'll move on. Yeah, that's all I have of her.
Okay. And Mr. Lewis, can this witness be excused?
No, Judge, I want to redirect on one question.
Okay, go ahead.
Where the court, you said that one of the children's fathers resides in Alabama in a jail. Is that correct?
Correct.
Is that this particular child, meaning Ariana's father?
No.
Okay, thank you. No further questions, Judge.
Okay. All right. And may this witness be excused?
Yes, Your Honor.
Okay. Thank you, Ms. Presley.
Thank you.
All right, Judge. So returning to our state statute, in paragraph 2, I am looking specifically at letter A, which talks about the accused financial assets. Her assets were her job that she had at Dollar General that was interrupted by those persons who decided to intrude, destroy, and do damage in that Dollar General, that decided to threaten violence against her and behave in an obnoxious way, and then who decided to throw a liquid on her after challenging her to come outside. So she's at this time lost that financial asset. It is the same financial asset that her mother has just gotten on here and testified that the 18-year-old, now 18-year-old, was using to help pay financial bills that mom was not able to pay because mom has to care for a disabled child, either age 3 or 7. All right. So the financial assets in this particular case are absolutely zero. She has no other earnings or income as are spoken of by paragraph B in this same position. She will need to get, however, another job somewhere else to fulfill paragraph C. Her money was used to pay for bills in the household that are not covered by the either the 3 or the 7-year-old's disability check. And so I now direct the court only to paragraph D, the purpose of bail. The purpose of bail, of course, is not to assume that she is guilty, is not to punish her. It is to ensure that she will report to court when she's supposed to, that she will not threaten or intimidate witnesses if released from jail, that she'll not interfere with the administration of justice, and she will not flee the jurisdiction of the court. I believe we have met our burden as far as whether she should be released on bail. As to the bail amount, Judge, until recently, I believe the court had the authority, and I'm going to take this off the screen now. Until recently, I believe the court had the authority to give an unsecured judicial release on this offense, on all of these offenses. I don't believe that the court has that authority anymore. So with respect to the criminal damage in the second degree, Judge, I'm asking the court to give an unsecured judicial release in this. There are no financial assets that are there present in the household. In fact, we've taken away, well, should I say, her assailants in the store have taken away her ability to have financial assets that she once had. And so I'm going to ask the court to give an unsecured judicial release on the criminal damage in the second degree. With respect to the first 5 charges by the police, they were aggravated assault, all 5 of them. Judge, as you know, I offered at the preliminary hearing an alternative thing that I thought that she was, if she in fact did this, more guilty of, that the court rejected, and that is that she, if in fact she did this, she used her weapon to cause her assailants to go away, to scare them away, and then to deter them from coming back and bothering her. The court rejected that argument by forwarding this matter on to Superior Court. And so at this point in time, Judge, I'm going to ask the court to give on all of the remaining charges of aggravated assault a $5,000 bond each, with a grand total of $25,000 for those charges. Thank you. So split bail is what I'm asking for. And if the court doesn't feel it has the authority to give a UJR on the criminal damage in the second degree, then a $2,000 bail there.
Okay. All right, Ms. Thomas.
Again, Your Honor, the court was party to the original testimony, so I'm just going to do mine as basically a follow-up to that. You know, 2 wrongs really don't make a right, particularly in this particular circumstance when somebody could have been gravely injured or killed. Now, defense counsel will have that provocation from the victims was sufficient for this defendant to break out a gun and start shooting. State will contend the exact opposite, which brings us into why she is, at this point in time, I believe she would not meet the Ayala criteria for under subsections B and C. First, words and water do not equal bullets and gunshots when people could be gravely injured or a person could be killed. Defense counsel has noted that this young lady has no history. She just turned 18 in July. That is also, Your Honor, not the no history part, that's great. But the just turned 18 young ladies, young people at that age are volatile. They tend to overreact. She's probably the best witness of that unfortunate reality that I've seen in a while. The two women that came into, the two victims that came into the store, they said some unpleasant things to her. One of them threw a cup of water at her. There's been no testimony from anybody that says that either one of those women attempted to physically harm her, used a knife, used a gun. No evidence that none of that ever happened. They exited the store. Her manager, that's the key part, actually. Her manager told her, do not go outside of the store. Do not. That's where I think that age element kicked in, Your Honor, because she wasn't hearing that. All she knew is that she had been offended and that she was going to get, I guess, the last word. She did choose to exit the store. She did choose to pull a weapon, which was verified by an independent witness who was just there to shopping with his child, who could have also been injured. And she chose to shoot at the 5 victims in their vehicle. That vehicle ended up running off the road. It's by the grace of God that they were not struck by any of those 4 bullets that went into that car. It's by the grace of God they didn't run off the road and hurt themselves just by the wreck. It's by the grace of God that they didn't hit anyone else in the process of wrecking. For some reason, nobody was hit by one of those bullets. But that was grace. That was not the judgment or discernment of the defendant before the court today. And I do believe that she is a danger to the community. Her judgment is obviously bad. I do believe she's a risk to reoffend. Who knows when the next customer may say something that she doesn't like or do something she doesn't like. She may break out a weapon then. We already know what happened the last time. And as I've mentioned previously, no, she does not have any history. But she literally started out with a bang when she acquired one. I believe there was some conversation also regarding her being a support for the family. Her mother testified that none of the children in the home are hers. As a person living in the household, yes, it is a good thing that she chooses to contribute, but that's a choice. It is not our obligation to support anyone in that household. What is her obligation is to conduct herself in a civilized community by not overreacting and bringing a gun to a water fight. Your Honor, at this point, state would ask that no bond remain on the counts of aggravated assault and that on the count of criminal damage to property, that bond remain at $4,000. Thank you.
I have a reply, Judge.
I was going to ask Ms. Thomas, if I was inclined to give a bond, what amount would the state want to see in this case?
Yeah, I would prefer no bond. I'm really afraid of what she'll do when she gets out. But if the court was inclined to set a bond, the state would ask that it would include the conditions of no contact, stay away from the victims, stay away from that location, and she's to have no further violations of the law, and stay in the state of Georgia.
But in terms of an amount,
I believe what I offered the defense, if they were so inclined, was $20,000. He asked me a question, Mr. Lewis. Would you like to answer?
But you can't share to him what we talked about. You can give him.
You can recommend. I guess you can't talk about what you did during negotiations. So, but you can still recommend a number if you
have
one in mind.
I do now.
Okay.
On each count of aggravated assault, state would recommend at this stage $25,000, and I think that would come out to 125, plus the 4,000 is already on the criminal damage to property
Okay.
with the
And
aforementioned conditions.
Okay.
And
Miss
now my
Lewis.
reply. Thank you,
Yes, yes, sir.
Judge.
Go ahead.
Judge, there were a lot of things argued here by the state that weren't in evidence. It was absolutely true that the car driven by the assailants' cohorts was down the street, but there was no evidence offered that any car wrecked. Secondly, Judge, I would ask the court to never penalize somebody because of their gender. The state said that young ladies that age are prone to
Yeah,
overact.
I'm going to object. I believe that was a
100%.
misstatement on my part, and I did rescind that to say young people.
Okay, then now
I understood it to be young people. That's
okay.
sorry. Yeah.
All right. So
Gotcha.
I'm glad that that's rescinded because that absolutely is a bad look. I would absolutely, Judge, submit to you that a child of a parent has a duty to that parent, especially when that child resides in that household. To suggest that children don't have a duty to the parent, forget about my biblical upbringing, but it simply goes against the good order, to suggest that a person who is a child should not contribute to the household that they live in with their income. Judge, the testimony from the witness at the preliminary hearing was that he believed that Ms. Wilson Presley shot at the car and hit the car. He testified that she shot her gun and a bullet was found in the ground or on the ground 3 feet away from where she was, though the person throwing the liquid that he now believes is water onto Miss Presley. So in essence, one of the persons who the state is identifying as a victim threw a liquid and that liquid hit Miss Presley. The testimony is that Miss Presley shot her firearm and the bullet was on the ground 3 feet from her. So there was no accidental this, that, and the other if we believe the witness. What if we believe the witness that testified what Miss Presley shot at, she hit. As far as the witness, an independent witness's child, there was no testimony about the independent witness's child ever being in the line of fire, or even that the witness was in any line of fire. There was no independent witness's child in the store. There was testimony from the state's witness, and that's the only witness I've been speaking of in this case so far, that the manager had to herd the people out of the store after they came in, hurled insults, and did not accidentally knock things off the shelf, but intentionally knock things off the shelf. And there was testimony from the state's witness, the detective, that the persons, after being herded out of the store by the manager, waited outside of the store. They didn't leave, but they waited outside of the store. And there was testimony by the state's witness that no one called the police to aid Miss Presley, the employee of that store. After all of those events had occurred, the police were only called after Miss Presley allegedly discharged her firearm in defense of herself. Now, I would submit to the court that if in fact she did discharge her firearm in defense of herself, she may have responded in a way that this state does not authorize in its law, that a gun be used when there is no gun or knife on the other side. But I would submit to you that I asked about questions of gas and alcohol. The officer didn't testify that he smelled gas or alcohol, but he didn't know what was in that cup, and neither did Miss Presley. You see, nobody gave her any warning as to what she was being assaulted with. And so we don't know what it was, even to this day. We believe it was water. Finally, Judge, the state offered an amount of $25,000 and the original for each of the aggravated assaults, which would be $125,000. And
Yeah, I'm going to object at this time. I did not offer that amount. The court asked what a tentative recommendation, which is what I provided to the court. That does not reflect any offer made by me.
Take it any way you want to, Judge. She told you $25,000 on each aggravated assault charge.
I understand what you're referring to. Yeah.
Yes, sir.
Gotcha.
And she asked the court to continue the bond with respect to the criminal damage in the second degree. Judge, that is, in my calculations, $129,000. So what the state is asking you to do, in essence, is what it asked you to do originally: give no bond, because $129,000 we have just heard from Mom and me is well outside of anything that they can obtain. I would submit to you, Judge, that the law commands, if you see these IALA factors as being satisfied, command that she get a bond, the least intrusive bond. 1761, as well as IALA, requires that you give the least bond, that not one designed to keep her in jail, but one designed to ensure that those factors of IALA are met. So that being said, the state asked for some conditions. I would submit to you that we have no objection to those conditions. They address IALA very directly. The assailants slash victims, purported victims, if they come back to the Dollar General, she doesn't need to be there. Mom has already testified that she has never seen those individuals before, all of them. And I went through each of them. So that should take care of that. The defendant should be allowed to seek income elsewise while this matter makes its way through the court. And then finally, we've learned that there is a person who is unrelated to this defendant who is in an Alabama jail. I don't think that she can get the jail people in Alabama to let that person out who's not related to her, to aid her in some way in going to Alabama. She is a high schooler. I would like for her to continue high school so that she can graduate, unlike so many. Lastly, Judge, I have no idea where all of the conjecture came from about persons, my client's age. I would submit to you that is a problem. That is a problem, and it seems to be evident elsewhere. So, as an additional condition, though not asked for specifically, I'm going to ask you to add an additional condition that she possess no weapons or not while she's out of the jail, and that will take care of that. But a bond more in line with what I asked for is what the court should put in place. Thank you.
Okay. Thank you both. I do think that bond is appropriate in the case. There is no criminal history. I know part of that's because she's 18. But you know, I know Miss Wilson Presley is a worker and has had jobs, and um, I I particularly I am finding that a bond is appropriate because the victims here um, that there was not any evidence that there was any that they did not know each other. That this was an incident that occurred in the defendant's workplace. And what we're really dealing with is her response to what happened there. So I am going to find that bond is appropriate. I am going to do a total bond of 40,000, and the way I got there is $7,500 on each aggravated assault charge, and I will knock the criminal damage bond down to 2,500, and that gets us to an even 40,000. Um, then on special conditions, we are going to look at special conditions here. So we'll add a special condition of while out on bond, the defendant may not possess any weapons, including firearms. Um, no contact with the alleged victims. That she must stay away from this location where this occurred. I do think a curfew would be appropriate. That does still allow her, with the exception of church work, school, medical appointments, attorney appointments. But otherwise, a curfew from 7 p.m. to 7 a.m. every day. I think that would be appropriate here. Do either of you have? Yes.
Just for purposes of make sure my notes are correct, it's 7,500 for each count of aggravated assault and 2,500 for the criminal damage to property.
Yes, and I think that should get to 40,000 if my math was right here. Let me double check it. 5 counts, 25, 40,000.
15 and 15 is 30.
Yes, Judge, that I concur
Got
with your amount.
42. Okay. All right. In terms of the special conditions that I've gone through, did anyone have any, did you see any of those posing an issue or any other conditions that might be appropriate here?
Judge, does your medical exception to the curfew, would it permit her also medical for herself or her sibling? I don't know the nature of that disability, but I know it's enough for the government to be involved. So does it permit her to come out for that purpose as well?
We can put that in there. I can add, if we said family
Yes,
doctor's
sir.
appointments, I think that would sort of cover that way if she needs to transport her sibling to a doctor's appointment, that should allow it.
Yes, sir.
There.
Thank you.
Okay. All right. Okay. Well, I think that'll take care of everything. I will get that bond order drawn up in just a bit and filed, and that should take care of everything on this case. So, deputies, you can take Miss Wilson Presley back. Thank you, ma'am.
Yeah, I just want to be sure my notes are correct again. She's to have no contact with the victim. She's to stay away from the incident location. She will have a curfew, with the one exception being any type of medical emergency.
No, several exceptions. Church, work, school, family doctor's appointments or medical appointments, or attorney appointments between 7 p.m. and 7 a.m.
Thank you, Judge.
Okay.